painter who once said that applause is nourishment. And with that, I just want to thank you all for the light lunch. Derek, thank you for inviting me. It's always an honor to address the symposium. I think you're doing a great job as chair. I know you're pushing very hard to return this section to normalcy. Today is a major step in that direction, and I think everyone owes you a debt of gratitude. Thank you, Derek. I mean, I don't know about you, but I was really excited about coming back to a live event and seeing everyone and like old times. I mean, speaking for myself at least, I think we all look the exact same we did 3 years ago, give or take about 10 pounds, right? I also have to thank my associates, John Paone III, Victoria Paone Rosa, for assisting me with my article, which is found. Go ahead, give it to them. It's found on page 1 of your materials. Thank you guys. Keep up the great work. Let's talk about what happened in 2022 from 20,000 miles high. It's another lean year, at least as reported cases go. And the reasons are several-fold. I don't have to tell you, you experience it in your daily life. First, the court system is slow recovering from the pandemic. And so that's obviously a drag. When cases are not tried, there's nothing to appeal. So it's no coincidence that when you look at the cases, reported or unreported, a lot of them are domestic violence, because those trials still must go on, and a lot of them are interlocutory appeals. Secondly, as noted by our distinguished president of the bar, Geraldine Lawrence, there is a critical shortage of judges throughout the state. Some vicinages have literally closed down trials. I was with Judge Wilson the other night in Somerset County, and he made it clear there are no trials in Somerset County going on. So again, you have no trials, you don't have an opportunity for reported cases. The governor and the legislature should be ashamed of themselves. The only thing that's keeping the system alive right now are the many recall judges who have come back and are pinch hitting during this time of crisis. And so that's the general report card. And of course, you know, the result of that is, what do we do as attorneys? We look to ADR, take your case to arbitration. And that's a good thing, but arbitration doesn't advance the case law. So at the end of the day, it's a tough road to hoe. There is some good news to report for 2023, however. The Supreme Court has accepted cert in the matter of Cardelli versus Cardelli, which will address the standard for making out a prima facie case of cohabitation by a payer of alimony who is seeking discovery in furtherance of an application to terminate an alimony award. So we know that at least there will be one major case from the pipeline coming through for 2023. Now on to the top 10 for 2022. The first case, the most important case in my opinion, is Moynihan versus Lynch. This is one of Justice Barry Alvin's final opinions before his retirement, and it's on the subject of palimony. To understand it perfectly, we've got to go back and have a brief review of the history of palimony in the state of New Jersey, and in specific, what are the rights of two people who choose to live together in an intimate relationship without the benefit of marriage. In the old days being before 1939, couples who lived together for a certain period of time without being married could qualify for common law marriage, such that even though they were never legally married, they could receive the same benefits of people who were married. And that went on until 1939 when, because of religious interest or what have you, the state passed NJSA 37:1-10, which abolished common law marriage in New Jersey. So then we go from 1939 into the 1970s, which is a dark period, so to speak, with regard to couples who are living together without the benefit of marriage. And then something happens in California. There's a case called Marvin versus Marvin, involving the famous actor Lee Marvin, who was in The Dirty Dozen and a bunch of other movies, who lived with a woman named Michelle Triola. And they did everything just like a married couple, including Michelle Triola going to court and getting her name changed to Michelle Triola Marvin, with no objection from Mr. Marvin. And then, of course, the parties separate what to do. The attorney for Michelle Triola is a man by the name of Marvin Mitchelson, and he comes up really with this palimony idea and the legal theory that there was a contract implied between these two that should be enforced. And voila, we now have the birth of palimony, at least in California. But like the jet streams that start in California, they ultimately make their way to New Jersey. By 1979, New Jersey Supreme Court issues Kozlowski, which recognized the implied contract formed by virtue of the parties living together. But New Jersey doesn't stop there. From Kozlowski, we go to Crow versus Joya, which meant that palimony claimants could now receive pendente lente support. And from Crow, we go to Roccamonte, which said that palimony claimants can now make claims against the deceased partner's estate. And then from there, in 2008, came the coup de grace, Devaney versus Las Esperanzas, in which the Supreme Court says, you don't even need to live together to qualify for palimony, you just have to show a, quote, marital-type relationship. So much so that Justice Rivera Soto commented in that opinion that potentially every dating relationship has the potential to give rise to a palimony claim. Well, Devaney forced the hand of the legislature. And so by 2010, the legislature decides to put all of the law of palimony under the statute of frauds. What does that mean? It means you need a writing. You don't have a writing, we're not going to apply a contract. It's not going to be a he said, she said thing anymore. So they passed NJSA 25:1-2. But the legislature goes a little further, right? It says not only do you need a writing, but that writing has to be reviewed by independent counsel for both parties. The legislature might as well have abolished palimony, as if to think that's what they were trying to do. But as a practical matter, you have to ask yourself, how many people are going to live together without the benefit of the marriage, have a writing, and then have attorneys review it? Now you're ready for the Moynihan case. Moynihan is a flight attendant, and Lynch is a pilot. And they have an 18-year relationship together. And ultimately, they actually purchase a house. The house is purchased in Lynch's name. Moynihan puts down the down payment. And it seems that the purchase of the house provokes the party into entering into a writing. And there is a writing which talks about what's going to happen if they break up, what's going to happen to the house, what's going to happen regarding financial issues. And sure enough, by 2015, the relationship ends, and here comes Moynihan seeking to enforce the writing. And of course, Lynch is denying that the writing is viable. Why? It's signed by the parties, it's even notarized. Well, they didn't have independent counsel by both sides review it. And we know what the statute says. That's what the trial court said. I read the statute. It says that neither party had in turn review the document. It's therefore unenforceable. But the trial court did try to make up a little bit by saying, well, even though you don't have no rights under the palimony, we're not going to enforce the agreement, I'm going to treat Ms. Moynihan as a landlord-tenant dispute and give her some relief there. Neither party's happy with that. They both go to the appellate division. And the appellate division says, yeah, we read the statute, and it's clear that the statute is constitutional. It does not impair the right to contract. It serves a legitimate public purpose. And it protects the rights of people who are looking to enter into palimony agreements. And so Moynihan is left in the lurch by the appellate division. Fortunately, the Supreme Court decides to accept certification, and the matter goes up. And we have amicus appearances by Gerald Lawrence on behalf of the American Academy of Matrimonial Lawyers, and by Robin Bogan on behalf of the State Bar Association and our family law section. So we're fully armed, right? The Supreme Court finds that the attorney review requirement is unconstitutional and violative of the due process guarantees set forth in Article 1, Paragraph 1 of the New Jersey Constitution. The court made clear that the right of individuals to govern and manage their own affairs is an implicit guarantee of the New Jersey Constitution, and the requirement that you have a lawyer infringes upon that right. Or, as Justice Alvin asked rhetorically during the oral argument, how come you don't need an attorney when you enter into a contract to buy a car? You ever see those contracts? How come you don't need an attorney to enter into a matrimonial settlement agreement or a property settlement agreement? How come you don't need an attorney to enter into a prenuptial agreement? You could waive the right to counsel there. Okay, great. So now we know we don't need counsel to enter into a palimony agreement, but we still need a writing. And what all of you should be thinking about is, how much of a writing are you going to need? What is enough? As I said the other day to Geraldine, would a Valentine's Day card do? if I write in it, I promise to take care of you for the rest of your life if you stay with me. Signed, Love, John. Would that qualify? We don't know. You ought to be thinking about that. But remember I said to you, these cases are not going to have writings. You're not going to have attorney review. You're not going to have a writing. So what's going to happen? The Supreme Court did not address the equitable arguments that were there, right? So as a practical matter, we don't know. Are we going back to the dark period between 1939 and the 1970s again? Will the courts entertain these equitable arguments? Partial performance, promissory estoppel, unjust enrichment, quantum error, quasi-contract. It will be our family court judges who will make that decision. The Dan Browns of the world, the Judge Higgins, the Judge Goldens, and all those who are here with us today, you're going to get those cases walking into your door. And you're going to have to answer the following question: whether or not you're going to allow a fraud to take place in your court, or whether or not as a court of equity, you're going to apply these equitable principles to prevent some kind of an unfortunate consequence. The second case is really kind of paired with joining in. We're going to do that real quickly. It's Primer versus Harrison. It's written by our friend Judge Annie Hall. And basically what Primer's main holding is that Moynihan is to be given retroactive application. So where you have a written agreement drafted after the statute of frauds was amended, you don't need an attorney, and you didn't need to be in the pipeline. You're free. Okay. Remember one final thing before we leave the subject of Paone. The statute of frauds was amended on January 18, 2010. Write that date down and put it on your calendar. You may need it someday. It's only 13 years ago. And people who have been living together before that time and who break up now still have the rights of contract that can be implied under the old law of Paone Zaleski, etc. Have any doubt? Read Bodas versus Kuttrick, read Baker versus Ross, which held that the new Paone law on the statute of frauds is not to be given retroactive application. Okay, now you're up to date on Paone. We're going to case 3, AAR versus JRC. This is an appellate division case dealing with domestic violence involving a pro se defendant. So the case begins, and the trial judge asks the pro se defendant, "Are you ready to proceed?" And the pro se defendant says, "Yeah, sure, I'm ready to proceed." And off we go to trial. And the trial goes forward, and sure enough, would you know it, the pro se defendant is found to have committed an act of domestic violence. And so now the judge starts telling the pro se defendant the potential consequences of the domestic violence finding that has been made. And at that point, the pro se defendant raises his hand and says, "I would like to have an attorney, if you don't mind." And the judge says, "We tried the case already, you're too late." Well, later on, the pro se defendant actually hires an attorney and files an appeal. The appellate division reverses and remands and finds that although there is no right to an appointment of counsel in a domestic violence proceeding, the failure to advise the defendant of his right to retain counsel is a violation of his rights to procedural due process. The pro se must also be advised before the trial of the potential ramifications that flow from having been found to have committed an act of domestic violence, another procedural due process right. Now let's talk about how this case concerning a pro se is impactful in terms of your practice. And here's the magic sauce of this. Sometime in the future, a client's going to walk into your door requesting that a prior FRO entered against him be dissolved. These are Carfagno cases. I mean, think about it. We've been entering FROs since 1981, and there is no sunset provision regarding a final restraining order. So there are literally hundreds of thousands of FROs out there. And these cases, at some juncture, will come to you. When that happens, AAR suggests the first thing you need to do is look under the hood. What do I mean by that? Go back and take a look at that proceeding, especially if that defendant was a pro se. Was he advised prior to trial of the right to get counsel? Was he advised prior to trial of all the ramifications that can come about with a finding of domestic violence, such as financial penalties, such as registry in the domestic violence registry, fingerprinting, and so on and so forth? In addition, the client may come to you in the future with regard to a contempt. And again, when that happens, look under the hood of the FRO. Was the FRO entered without giving the defendant proper notice that is now required under AAR? Take a look at the opinion cited in our materials, State versus Laura. It comes out of a drunk driving case. And in that particular case, the drunk driving offense had to be treated as a first offense when the underlying conviction was defective because of the failure of the court to advise the defendant of the right to counsel. Very similar here, right? And finally, AAR would also seem to mandate that any defendant who requests an adjournment of the first trial date should be able to get that adjournment. This is relevant for you. Why? Because if you're like me, you're sitting in your office on Tuesday and you get a call from a client who wants you to appear on a TV trial on Wednesday, right? Isn't that exactly how it goes? Now, as a result of AAR, you can be fairly confident that with regard to the first listing, instructing the client to request an adjournment so we can come in, properly retain you, and so that you can properly prepare for trial can happen. So that's the relevance of AAR. We go now to case number 4, DNC versus KHG, another appellate division opinion by Judge Walla. This one you're going to want to read if you're ever appointed as a guardian ad litem on behalf of an incapacitated person in a divorce case, or if you're involved in a divorce case with a guardian ad litem. It's a 31-year marriage and the husband files for divorce. He owns a tavern and other businesses. The wife is retired and was diagnosed with a myriad of mental health issues, including bipolar disorder, schizophrenia, and with consent, a GAL, guardian ad litem, is appointed for the wife by the family judge. The GAL in the order is authorized to attend all proceedings on the wife's behalf and to make all financial decisions for the wife. But this GAL is a pretty smart GAL, and she doesn't just stand with that. What she does is she takes the order and she goes to the probate court asking for a judgment of guardianship, appointing the parties to emancipated children to act as co-guardians for the wife. The probate judge determines the wife is incapable of managing her own affairs and orders that the children serve as permanent co-guardians and to participate in the divorce proceeding on the wife's behalf. This is wonderful. The children come back to family court with the guardian ad litem, and subsequently they enter into a settlement agreement. They resolve everything. There's a buyout of alimony. There's a lepus waiver. The wife receives about 30% of the business, and all other issues are resolved. What happens next is what happens every day in the family law practice. And this is the reason why we love it, right? Because what happens is the unexpected. And what's unexpected here? In 2019, the wife obtains evaluations from 3 doctors, including one who previously said she was incapacitated, who now all agree she can manage her own affairs. And what happens after that is also expected, because once the probate court says, yes, you can manage your own affairs, she now files a motion in front of the family court judge to vacate the judgment of divorce and vacate that agreement that was entered into by her children. Why? The children weren't neutral. They were favoring dad, not mom. And she's also complaining about the agreement. The appellate division holds that the standard for vacating a settlement agreement is unconscionability. And it's not enough for the wife to argue that she should have received a better deal. Rather, she needed to show that the agreement was so manifestly unfair that no reasonable person would accept the terms under the circumstances. The appellate division could not find that the children of the guardian were engaged in any impropriety or that they were not neutral. The guardian had the assistance of the guardian ad litem, who was a competent attorney who worked with them to settle the matter, so the request to vacate was denied. Here are the takeaways. Every day, we go to court, and the family courts put through a divorce, and there's a settlement agreement, and the judge usually says on the record, you know, I've taken no testimony as to the fairness of this agreement. That's true, but don't get confused, because if you want to come back and contest the agreement, it's next to impossible to do so, because now you're no longer dealing with fairness, now you're dealing with the high bar of unconscionability to vacate a put-through. An agreement so bad that no reasonable person would accept it. For you civil lawyers out there, it's like having to show that the doctor who was supposed to operate on the left leg operated on the right leg, right? So it's a pretty tough standard. Number two, while the trial court could not on its own order a buyout of alimony, while the trial court could not on its own order an anti-lepus waiver, these are provisions that are agreed to every day by parties and family attorneys, and the mere fact that the court could not order it was not a basis to vacate this agreement. That is very comforting to know, because it shows that the court understands that in order to settle cases, sometimes we have to be creative. And in that way, settled cases are different than cases decided by trial and by the court. Finally, number three, if you get appointed as a guardian ad litem, it serves you well to look around and see if there are suitable guardians who would be appointed by the probate court to make the final decisions for the incapacitated party. The GAL did it all right here, and this case serves as a roadmap for you in that regard. Case number 5, and I have to thank Judge Dalton for pointing this case out to me during our speech in Atlantic City. Kopik versus Moores, an appellate division case regarding lawsuits filed by a family law firm to collect counsel fees from past clients. There are about 10 lawsuits, and all these cases are combined and consolidated by the appellate division for your reading pleasure and convenience. What's at issue here is that the law firm's retainer agreement, which purports to say that any dispute regarding fees are to be resolved by arbitration. But what happened? How come we aren't in arbitration? Well, again, you can't go to arbitration if the client's not participating in arbitration, so now we're in court. Nevertheless, the appellate division has a lot to say about this collection action, and none of it is good for family lawyers. In fact, it's the worst news possible. Number one, the court says to the law firm, you're in the wrong court. You filed it in the family court. This can't be in the family court. Well, why can't it be in the family court? Appellate division decided Giarosa only a few years ago. And Giarosa said these post-judgment collection matters should be filed in the family court, as that's the court that was in the best position to assess the reasonableness of the attorney's work and whether or not the fees charged were justified. Now the appellate division says, when the court amended Rule 4:3-184, the rule as revised effectively overruled Giarosa, and the rule now dictates that suit for fees must go to the law division. That's a bad thing. What does the law division know about the family action, where the fees were incurred? Moreover, in the law division, you're more inclined to get those knee-jerk counterclaims for malpractice and requests for a jury trial. This opinion is nothing short of devastating for those family law practitioners looking to file lawsuits to collect fees. So practice tip number 1, don't file suits for fees. Rather, be vigilant in collecting fees while the case is pending. Demand added retainers when old retainers are consumed. Be prepared to leave the case if the client refuses to pay. Petition the court for the sale of assets and the creation of a litigation fund where possible. And always remember, when the client says, you'll get it in the end, you usually do. Number two, remember I said the law firm's agreement intended to have the fee dispute resolved in arbitration. The appellate division was critical of that too. Go back and take a look at the Supreme Court case of Delaney versus Dickey, which said attorneys are, quote, required to discuss with the client the basic advantages and disadvantages of a provision in a retainer agreement that mandates the arbitration of a future fee dispute or malpractice claim against the attorney. Here, there was no record to confirm whether that ever happened. Moreover, the appellate division found that the language in the retainer agreement was ambiguous, confusing, did not state what arbitration is and how arbitration is different from proceeding in a court of law. The Supreme Court in Delaney versus Dickey said they were going to be charging a committee to report to the court on how arbitration is to be handled in a retainer agreement. Until they do that, you attempt to put that provision in your retainer agreement at your own risk. What I am saying to you is not that arbitration is a bad thing, it's a good thing. I just don't know if you're going to be able to make it stick until the Supreme Court gives us further guidance. In the interim, read Delaney versus Dickey. Finally, in preparing a certification in support of the motion, the law firm failed to address the factors under RPC 1:5-8. Take a look at that rule and the 8 factors. Every time you go to court seeking fees or file a certification of services, you should address those 8 factors. Case number 6, Devers versus Devers. Yes. Yeah, sure.
Just very quickly. Is this on? Oh, sorry. I think it's on. Just as an update on COPAC, just so you know, the State Bar Association, we just approved proposed court rules, sorry about that, proposed court rules trying to get these fee issues back into the family park. So stay tuned on that. Just keep that in mind.
Geraldine she's been wonderful, right? She's been a dream to have as our president of our park. And she picked up on this right away, and I know she's been working on it. And if anyone's going to get it done, it's going to be Geraldine. And if she can't do it, I'm sure Tim Crawford will do it. So one of the two. Let's go to Devers. What does it mean when a judge says in an order that your requested relief is denied without prejudice? You know, when I first started practicing, I don't remember courts regularly denying requests without prejudice with the same frequency that they do today. Maybe Frank and Mark can kind of chime in on that. In my early days, I remember the courts just reserving, right? So much so that when I first started practicing in Middlesex County, I was told that the presiding judge in Middlesex County had a nickname, and it was Reserving Irving. Reserving Irving Rubin, right? But alas, the AOC sent out a directive. You can't be reserving, judges. And so now there's not so much reserving that I see. But there's an awful lot of denials without prejudice. But what exactly does that mean? Well, in Devers, the appellate division corrects the trial court for misusing the term. It's a 23-year marriage. The fight is over a hedge fund managed by the husband in the United States and the Cayman Islands. Specifically, the hedge fund is in the course of winding up its affairs. It transfers $1.5 million into an LLC owned solely by the husband, and that forms the dispute. The wife says that the LLC is subject to equitable distribution. The husband says no, the money in there is owned by the investors. So they actually have 34 days of trial. You wonder, right? But this case is an older case, probably started pre-pandemic. They have 34 days of trial, not only on this issue, but a bunch of other issues as well that separate the parties. The trial is stopped before final decision. The parties settle everything, with the exception of the hedge fund issue. That they reserve for a future plenary hearing. They get to that plenary hearing, and they have another 3 days of trial. The court makes its decision. It says, the wife's claims are denied without prejudice. My goodness gracious me. What the heck's going on here? After this final hearing, denied without prejudice. The court, in its decision, the trial court's decision, holds that it lacked subject matter jurisdiction over the account. The trial court relied on the Investment Advisors Act, which the court found granted the federal court's jurisdiction over all suits in equity and law over this type of fund. Now let's just stop for a second. Now I don't know much, but whenever somebody tells me that in order to get equitable distribution, I have to go to the family court, I'm calling BS on that, right? Okay. 3 months later, the wife decides to file a motion for reconsideration of the order denied without prejudice. But the trial court says, I'm sorry, you're too late. That was the final order. She says, wait a minute, I thought it was denied without prejudice. So the wife then files a notice of appeal. But hey, guess what? 3 months away from a final order, she's out of time to file her appeal. Nevertheless, the appellate division Judge Clarkson Fisher takes the matter and looks at the mess that was created by what the trial court did here and tries to unravel it. First, it interprets the trial court's order. What the trial court really meant to say was that, in reality, the wife's equitable distribution claim for a lack of jurisdiction was denied, but the decision was not intended to preclude the wife from asserting a claim in what it believed to be a proper forum. On top of it all, of course, the appellate division found that the trial court was also wrong about the Investment Advisors Act, finding that the federal government and the state have concurrent jurisdiction. I told you that was BS, right? So the moral of the story is, saying without prejudice, without more, is often confusing, and practitioners as well as judges are well advised to back up the use of that term with further clarification. For example, without prejudice and not an adjudication on the merits. Without prejudice, as the dismissed claim has not been finally resolved and can be later reinstated. Without prejudice, and does not bar reinstitution of the same claim later in the case or in a subsequent action. Without prejudice, The dismissed claim has not been finally or fully considered. Be careful using the phrase without prejudice. Case 7, Steiner versus Steiner. I included this case because of bifurcation, what you got to know about that. So what is bifurcation? That's when the court enters the divorce first and reserves for a later time the decisions on equitable distribution, alimony, and all other issues in the case. Years ago, the AOC circulated a directive to all family court judges, warning them against bifurcating cases. The fear was, once a divorce was entered, the parties would never settle their financial differences, right? And the calendar would be further backed up. So as an inducement to helping to resolve matters, hold the entry of divorce over the heads of the litigant. If you want to move on with your life, if you want to get remarried or whatever, settle your case. We're not going to let you cut the line. That's what the AOC had said to the family court judges. And ultimately, they backed that up by having a rule in 2011. And that rule is 5:7-9. And that rule says, hey, family judges, we don't even trust you. So bifurcation applications have to be decided by the presiding judge of the family court. And then only in extraordinary circumstances and for good cause shown. So the question is, what constitutes extraordinary circumstances? So if you asked me for my professional opinion before the Steiner case, I would have said that, I don't see bifurcation very often. It's kind of as rare as hen's teeth. It's usually when a party is extremely ill and there's a concern that there's going to be a death before the divorce, and as a result of the death, someone's going to fall into the black hole under car versus car, because with the death comes the death of equitable distribution. And it's within those circumstances that I see bifurcation. But I don't see it really in other ways. That's what makes Steiner so important. Because the parties here were elderly, but no one was on death's doorstep in Steiner. Let's look at the facts. The parties were married in 1955, and the wife files a complaint for divorce in 2018. The husband's approaching 90, the wife is in her 80s. The parties are still living in the same home, so there's no attempt to file on the 18-month separation no hold grounds. The complaint was filed on irreconcilable differences. 1 year after filing her complaint, the wife moves to bifurcate and to have the divorce entered. The presiding judge grants bifurcation, and later the divorce is granted after a contested hearing finding irreconcilable differences. The husband ultimately appeals. As I explained, the husband is now challenging bifurcation, but also the granting of irreconcilable differences. The appellate division makes clear that trial judges have great discretion in determining whether irreconcilable differences exist. Almost paraphrasing Justice Potter Stewart from the 1964 Supreme Court case on pornography, which you may remember from law school, Jacobillas versus Ohio. The appellate division says, quote, family court judges know irreconcilable differences when they see them, and as a result, sustain the decision of the trial judge to grant the divorce. Now let's get back to the bifurcation issue. Because remember, again, how did this happen? Why? Because A, the parties were elderly. There remained the, quote, potential, end quote, for the type of problems recognized in CAR, i.e. the black hole. So now, for the first time, you don't need someone on their deathbed to move for bifurcation. I mean, God forbid Frank Lewis ever gets divorced. He goes right to the head of the line. So that's new. Representing an elderly person perhaps gets you to the head of the line regarding a divorce. Number 2, the appellate division says here that bifurcation also could be granted in the interest of judicial economy. Well, how the hell is it economical to have 2 trials versus 1, Mr. Sobel tells me earlier? Well, in this case, what the trial judge and what the appellate division said was, you have this real big case, you're going to have all kinds of equitable distribution, discovery, whatever. We could avoid that if the husband prevails on the fight over the cause of action. So that's another reason why you have bifurcations. Again, if you ever need the question of bifurcation and you have a case involving that, take a look at Steiner. Case number 8, Sitko versus Cougar. Pay attention, all of my accountants here. I see David Pollock's here, I saw Judy Doyle, others. Hey, this is your case. I'm speaking to you. It may turn out that this is the most important Supreme Court case of the year, hiding in broad daylight. You may not have heard about it because it's not a family law case. But this hidden gem may be relevant whenever you are in a family law case where a business or professional practice is being evaluated. To understand the significance of this case, you have to go back to Brown versus Brown. And I saw Richard Hyman was here last night. I assume he's here today. Here he is, he's back there. He was one of the attorneys in Brown. I said, hey, Rich, were you the winner or the loser of the case in Brown versus Brown? He said, it depends upon how you look at it. I said, well, what about for the proposition I'm talking about? For that, he said we didn't do too well, but otherwise he won the case. Well, okay. What does Brown say? Well, if you've been hanging around lectures and seminars, you might have gotten the sense that what Brown said is that marketability discounts and minority discounts were no longer applicable in valuing a business. What is a marketability discount, you may ask? It's an adjustment for lack of liquidity of one's interest in an entity. It's based on the theory that there are limited potential buyers for the stock of a closely held corporation. Think of it this way. You want to sell an interest in your small business, or you want to sell an interest in your professional practice, it may take you a long time to find a buyer. If you want to sell an interest in 1,000 shares of Google, we can sell it like that. So, again, after Brown, practitioners believe marketability discounts are gone for good. Similarly, with minority discounts. After Brown, most practitioners believe they're gone for good. What's a minority discount? If you own less than 50% of the business, that partial ownership may be worth less than its proportional share of the business because you do not have control. And so in evaluating minority interest, we may discount it. Think of it this way. The business is valued at $100,000, 50% is worth $50,000. 20% may not be worth $20,000 due to lack of control. And in fairness to people who misread Brown, Brown's first paragraph reads as follows. The first paragraph, they put the whole in, we hold that under Balsamides and Lawson, the two big oppressed shareholder cases that came before it, neither marketability nor minority discounts apply to the defendant's 47% interest in a closely held corporation for purposes of equitable distribution. Now let's look at Citgo, and let's see how this case may have reopened our eyes on the questions of discount. Citgo is a family business, and Dad starts gifting interest in the business to his two sons. And the two sons have a dispute. One of them resigned from the business, ultimately give back his shares, and ultimately he has to file an oppressed shareholder lawsuit to recover the money for his interest in the company that he gave back. The protracted litigation lasts 15 years. You think you've got it bad in the family part? 15 years! And basically, the remaining owners do everything in their power to avoid paying this oppressed shareholder, including fraudulent conveyances, backdating stock certificates, and other improper and illegal conduct designed to strip the company of its value. Finally, after working its way up and down the court system several times, it's determined that the oppressed shareholder is going to be bought out. Now come the defendants, the bad guys, who say, hey, buying us out. Don't forget the minority and marketability discounts. And here's what's the front page news for us family lawyers. The Supreme Court didn't say, hey, remember Brown? There's no such thing as marketability and minority discounts anymore in determining fair value. They didn't say that at all. Quite the contrary. What they say is, fair value is not an exact science, and that courts may take equity and fairness into account when deciding the methodology and when to apply a discount of value. I was literally knocked off my chair when I read that. Because as a non-accountant, I always believed the math is the math. But now it's clear the court is saying we can change the math, and we can change the methodology to protect the good guy and to make certain that the bad guy is not rewarded. Remember here, the bad guy wanted the discounts so they could pay even less to the oppressed shareholder. The court said in this case, no discounts for you. In fairness, if you read the entirety of Brown, like Mr. Solo would do, remind me that he did, then you would know that Brown says the following. The general rule is that for purposes of determining fair value, neither a marketability nor a minority discount should be applied absent extraordinary circumstances. The record before us reveals no extraordinary circumstance. So what does this now mean for you? When you represent the business owner, your accountant is preparing the evaluation. Go back and read SIPCO and reread Brown, and you determine whether equities exist to argue for a marketability discount. This is not a decision for the accountant to make. And you're not doing your job if you're just relying upon the accountant to do the evaluation without cluing him or her in regarding the issue of marketability discounts. Merely taking the position that discounts are no longer allowed is a misreading of Brown, and if you had any doubt about it, now you have SIPCO. Case number 9. Mr. Sullivan.
Before you
Put your mic on.
Well, Mark figured out how to use the microphone. John, I can tell you that I finished talking. John is correct that these are legal issues. Accountants do not decide them. But the fundamental issue is what is the standard of value? And if you read Balsamides and Wheaton, and I believe there's a footnote in Balsamides and text in Wheaton that says the standard of value is determined by the policy of the statute. And now we get into the fundamental dispute that as to what is the standard of value in a divorce case of value in the business. Is it value as if it's being sold, or is it the economic benefits that the owner will receive in the future from the asset the parties build together? The accountant personally will tell you that it is the latter, it's value to the holder, because that's the policy of the equitable distribution statute. But they will say they're bound by Brown. And Brown and all of these other cases value things on fair market value, which is, as I say on cross-examination to a judge, why are we deciding cases on facts that are not happening, as opposed to deciding the case on the facts that are happening? So the standard, if you decide the standard of value first, that is the issue. I don't think any of these commercial cases are significant. You first have to argue what is the standard of value, and then go from there. And I'm so convinced that it is the economic benefits. If I get divorced, my wife is entitled to receive the economic benefits of what we have built over time. And that is why the reference to Brown and Balsamides is misleading. And the other thing about about Brown is when they rejected minority discounts, they did it on the facts of Brown. And Judge Wecker's opinion said, based on the facts of this case where there's no control, there's not going to be a minority discount. And I'll tell you something off the record. I saw Judge Wecker and I said, you know all these accountants that you threw out minority discounts? You know what she said? Didn't they read the opinion? Well, why should they? They're accountants. We're lawyers. You read the opinion. And that's it. Goes back to the standard of value and those footnotes.
You don't have to worry about getting divorced. You don't have to worry about getting divorced, Frank. Your case is going to be bifurcated. The judge is going to put all the economic issues at the bottom of the warrant.
That was prosaic. But here's the practical view. Two things. Rich Diamond, when he talks about William Brown, when we read the case, he didn't get the discounts. Who cares? If you prove it's a gift, it's exempt. The win loss. What is referred to, and you should read nothing in Balsamides and Wheaton, but I really kind of stress you read them. They're repressed shareholder cases. One of the things I love about it is the irony of it. They're decided differently. They're right after each other. They both go to the Supreme Court, and the Supreme Court says they probably should got them both wrong. Just kind of interesting reading. But the footnote that you should read in Balsamides, which is important, is it essentially says, because there's an issue whether the white hat could buy out the black hat. Did they have enough money to do that? And they might not. And the footnote says they're not even going to look at the valuation the same way with discounts between the black hat and the white hat in the same case, i.e., the black hat is not getting the discounts, the white hat may. So that's an important thing to look at when you look at the footnote. Right now, you're in a court of equity, and if you have a white hat, you could say you don't have to look at the discounts the same way. You can look at equity to to determine whether you're going to look at those economic discounts.
Mark, keep it simple. Is it true or is it not true that what the Supreme Court decided in both of those cases, their result was key to their belief as to implementing the policy of the statute? Correct?
Correct.
And that is what we have to do.
And when you have an oppressed shareholder statute, the idea is somebody's oppressed, the court's going to do something about that oppression. I leave it to your imagination in family law.
So here's the takeaway, right? Here we thought fault was out of the family court. It's coming back. At least as it relates to valuation principles, black hat, white hat. I agree with Mark 100%. I'm just looking around up here. What is this? Like the old people on the side, young people on the side? So, anyway, case number 9. MAP versus EBA. How minimum must the minimum contacts be in order to convey personal jurisdiction upon a New York resident who is alleged to have fathered a child with a New Jersey resident? The parties have what appears to be an isolated or limited sexual encounters in New York City, which result in the plaintiff becoming pregnant. The putative father is a resident of New York, and the mother is a resident of New Jersey. The matter proceeds before the trial court here in New Jersey, with only the mother appearing. The trial court finds paternity, grants child support. The alleged father, who learns of this, contends he was never served the process, and oh, by the way, New Jersey doesn't have personal jurisdiction over me. The father hires New Jersey counsel and petitions the trial court for dismissal, and also gets involved with trying to settle the case as well. The trial court denies the father's request for relief and concludes that because he had intercourse with a New Jersey resident in New York City, that was enough to subject him to the jurisdiction of the New Jersey court. The father appeals. And on appeal, the mother argues that when the father hired New Jersey counsel and attempted to settle the matter, he further voluntarily submitted himself to the jurisdiction of New Jersey courts. The appellate division agrees with the alleged father and did not find minimum contacts. Why? Number 1, look at NJSA 28:4-30.129A, which is a statute actually dedicated to the 7 factors for exercising personal jurisdiction over a non-resident individual to determine parentage of a child in New Jersey. Only 2 of those 7 factors were met. Interestingly, one of the factors is engaging in sexual intercourse in New Jersey, and the child being conceived by the act of that intercourse. That didn't happen here. Remember, the intercourse occurred in New York. Merely having sexual intercourse with a New Jersey resident outside of New Jersey is not enough to convey jurisdiction, and if it did, it would establish a, quote, boundless jurisdictional reach, said the appellate division. Think about it. You could be on a ship. An Alaskan resident could be on a ship and hooks up with a New Jersey resident, and now New Jersey has jurisdiction over the Alaskan resident. You like how I use the phrase hook up there? The fact that the putative father hired New Jersey counsel to attempt to settle the matter also did not convey jurisdiction, as to do so would go against the policies of the court, encouraging settlement and restricting settlement offers and negotiations from coming into evidence. This was a decision by Judge Clarkson Fisher, who wrote 3 opinions in the top 10 this year. As you know, he hit age 70, had retired from the Supreme Court. I believe he's been temporarily reassigned to the appellate division. He has a body of work in the family law which rivals only Justice Virginia Long and Marie Lyhots. If you go back from Stifler all the way to Temple last year, it's phenomenal. So he's done a phenomenal job as a judge on the bench handling family matters. The final case, number 10, JR versus AR, a published opinion out of the trial court in Monmouth County. Judge Aquaviva, then sitting in family. I actually met his law clerk last night who helped with the opinion. I am so impressed. It's a Hague Convention case, or at least one party believes it to be. The parties are married in the United States. They have a child in common in the United States. And then in 2016, they decide to go live in the Philippines and reside with the husband's parents. Things don't go too well there, such that by 2020, the wife takes the child out of the Philippines and relocates to Monmouth County. The husband comes to Monmouth County and petitions for the return of the child, because it's pretty clear, isn't it, that the child's habitual residence is in the Philippines. And under the Hague Convention, the child is to be brought back to its habitual residence for determination there as to custody. And And that's the way it's supposed to go. And by the way, the United States and the Philippines are both signatories under the convention. The husband loses. Why? How could it be? Well, it's not enough that each nation has signed the treaty. Here, the United States has not declared its acceptance of the Philippines' accession to the convention. It is not uncommon for the United States not to accept every nation's accession to the convention. Why? We want to be certain that the legal system of the country signing on is also sound. We also want to be certain that the other country's laws don't significantly deviate from the law in our country, which for the most part adheres to the best interest of the child. So if you have a Hague Convention case, you must do more than merely confirm that both nations have approved the convention. You must also confirm that each has accepted the accession of the other. And that, my friends, are the top 10 cases of 2022.